AML or CFT compliance programs and individual accountability. Different AML and CFT rules and laws have bounded the individuals and institutions for supervisory lapses by any means, whether by ignorance or by willful blindness, or by collaboration, or even by preventing the supervisors for revealing money laundering activities. Individuals may become prone to the legal punishments. In the past several years, guidance has been issued and laws have been passed seeking individual accountability at the senior levels of regulated financial institutions that have contributed to deficiencies in AML and sanctions compliance programs. In 2014, the Financial Crimes Enforcement Network (FinCEN) of the U.S. Department of the Treasury and the United States Financial Intelligence Unit (FIU) issued an advisory to financial institutions, reminding them to maintain a strong culture of compliance and that the entire staff is responsible for AML or CFT compliance. This advisory was followed in 2015 by a memorandum on individual accountability for corporate wrongdoing from the U.S. Department of Justice's Deputy Attorney General, Sally Quillian Yates. The Yates Memo, as it is often referred to, reminds prosecutors that criminal and civil investigations into corporate misconduct should also focus on individuals who perpetrated the wrongdoing. Further, it notes that the resolution of a corporate case does not provide protection to individuals from criminal or civil liability. Although the Yates Memo does not specifically address AML or CFT compliance, recent enforcement actions issued by U.S. regulators against financial institutions illustrate a continued focus on AML or CFT compliance deficiencies. In the United Kingdom, the Financial Conduct Authority (FCA) published final rules for the Senior Managers Regime 2015, which is designed to improve individual accountability within the banking sector. In relation to financial crime, the senior managers regime requires a financial institution to give explicit responsibility to a senior manager, such as an executive-level money laundering reporting officer (MLRO), for ensuring that the institution's efforts to combat financial crime are effectively designed and implemented. The senior manager is personally accountable for any misconduct that falls within the institution's AML or CFT regime. Finally, on June 30, 2016, the New York State Department of Financial Services (DFS) issued a final rule requiring regulated institutions to maintain transaction monitoring and filtering programs reasonably designed to 1. Monitor transactions after their execution for compliance with the Bank Secrecy Act (BSA) and anti-money laundering (AML) laws and regulations, including suspicious activity reporting requirements, and 2. Prevent unlawful transactions with targets of economic sanctions administered by the U.S. Treasury Department's Office of Foreign Assets Control (OFAC). This final rule, which went into effect on January 1, 2017, although the law may seem New York-specific on its face, numerous foreign banks fall within the law because they operate in New York. Specifically, the law covers banks, trust companies, private bankers, savings banks, and savings and loan associations chartered pursuant to the New York banking law and all branches and agencies of foreign banking corporations licensed pursuant to the banking law to conduct banking operations in New York. Moreover, the law also applies to non-bank financial institutions with a banking law license, such as check cashiers and money transmitters. Case study. From 2003 to 2008, Thomas Hayder served as the Chief Compliance Officer for MoneyGram, a money services business MSB specializing in money transfers. As part of his responsibilities, Mr. Hayder was responsible for ensuring that MoneyGram had an effective AML or CFT program that requires timely reporting of suspicious transactions. He was also in charge of MoneyGram's fraud department. During that time, there were thousands of complaints placed by customers who reported that they were victims of lottery or prepayment fraud, and they were instructed to remit money to fraudsters via MoneyGram agents in the United States and Canada. Although receiving a wealth of information from complainants, Mr. Hayder and MoneyGram's fraud department did not conduct an investigation of the complaints or the outlets from where the complaints were generated. An investigation would have allowed Mr. Hayder to suspend or terminate any agent participating in the legal activity. According to a December 2014 FinCEN assessment of civil penalty, Mr. Hayder failed to implement an appropriate AML program, conduct effective audits, or terminate known high-risk agents. As a result of FinCEN's investigation, Mr. Hayder was removed from his employment at MoneyGram in 2008 and was individually assessed a $1 million civil money penalty in 2014. FinCEN also sought to bar Mr. Hayder from working in the financial services industry. So individual willful obfuscation, safeguarding the criminals, willful blindness, or even supervisory lapses may case legal measures against employees. Different countries have adapted different levels of punishments in their legislative regarding individual supervisory lapses and other willful blindness. Hope from the above case, the practitioners must have understood the real consequences regarding supervisory or monitoring lapses. I will ask your favor for subscribing my channel for generating more such videos. Thank you for watching.